The governor is pleased to introduce the following scheme to provide, kindly underline this, limited livelihood, support and social security on humanitarian grounds on purely temporary basis, subject to consequential orders of any competent court, to distressed families of non-teaching staff in Group C and Group D categories who were recruited through 2016 selection process conducted by the West Bengal School Service Commission and who have lost their jobs and whose salaries have been discontinued for reasons beyond their control as a consequence of court proceedings which are yet to attain finality, as on the date and where review petitions are pending before the Honorable Supreme Court. Now, this presumption is absolutely preposterous. Then, whereas the state government, along with the West Bengal State Central School Service Commission, have already filed respective review petitions before the Honorable Supreme Court seeking review of inter alia the judgment and order dated 3rd April 2025 passed in civil appeal number so and so, with which appointments of Group C, Group D itself staff made pursuant to the 26 recruitment process were set aside. But these were set aside on the ground of the corruption. Whereas by reason of the said judgment, several thousand persons have been rendered jobless overnight, affecting their right to life and livelihood. And whereas the Constitution envisages the state to be a welfare state, where preservation of life of every citizen, every person, especially where it has been jeopardized due to reasons beyond their control, is essential for the welfare of the society. And whereas Article 21 of the Constitution of India enshrines right to life as a fundamental right, the obligation to protect which squarely rests with the state, especially in case of matters of public employment, and Article 41 of the Constitution of India also enjoins upon the state, within the limits of its economic capacity and development, to inter alia provide public assistance in cases of unemployment or old age or sickness and disablement, or in other cases undeserved one. And whereas it's a matter of record that Group C, Group D staff were employed under the state and whose employment has now been terminated by an order of court where the state was a party. And whereas the duty of the state to take appropriate measures to ensure that such persons are not deprived of their right to preservation of life overnight, and that such persons have a minimal amount of time to make a suitable alternative arrangements to ensure their livelihood. And whereas it has been done by the state in the past on temporary basis and subject to any consequential order as may be passed by competent court of law, state has formed an opinion to provide support to enable such persons to apply for alternative means of livelihood within a minimal amount of time, and therefore the scheme herein below is formed. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families or non-teaching staff in Group C and Group D categories in accordance with law until proceedings attain finality. But the basic perception of law is not vitiated. Filing review does not disturb the finality which has been delivered by the judgment. Now, therefore, in exercise of powers under Article 162 of the Constitution of India, governor is pleased to frame this scheme. What the distressed families? And this will come into effect from 1st April 2025. Distressed family means the immediate family of any non-teaching staff in Group C or Group D category who was recruited through the 2016 selection process conducted by the West Bengal Central Service Commission, constituted under so and so. I am not troubling my lot with that. Then kindly come to the next page. Registration to avail benefits under this scheme, and eligible non-teaching staff in Group C or Group D category who belonging to a distressed family must supply application, this and that. Then benefits. An eligible non-teaching staff in Group C and Group D category belonging to a distressed family shall be entitled to receive cash assistance of 25,000 and 20,000 per month, respectively, as livelihood support. The benefit shall be discontinued upon occurrence of any of the following events: on death of the applicant, on the date on which the applicant attains the age of superannuation, the finality to the illegal appointments. Upon the proceedings before the Supreme Court arising out of civil so and so attain finality through final disposal of the review petitions, or any other further petitions as may be filed in accordance with law by the Supreme Court of India, which was earlier, due to any other provision laid down in this scheme by the state government from time to time. This is the Miller scheme. This was wholly without jurisdiction and Miller to support the corruption which was perpetrated by the state itself. Kindly come to know, Miller, the Honorable Supreme Court judgment. That we have annexed that. Paragraph 45. Kindly turn to page 62. Page 63. This is the conclusion of the Honorable Supreme Court judgments. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the court that services of tainted candidates who were appointed must be terminated and they should be required to refund any salaries, payments received. Since their appointments were a result of fraud, this amounts to cheating. Therefore, we say no justification to alter the direction. The final direction of the Honorable Supreme Court is the tainted service goes and you have to return the money. Keeping this in mind, state government now engages them to support them out of the public fund. Then 46. For candidates not specifically found to be tainted, the entire selection process had been rightly declared null and void due to the egregious violations of illegalities which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Further, no candidate can be appointed once the entire examination process results have been declared void. Now, these are the two important Miller directions. The rest are not very important. And then kindly come to paragraph 51 at page 65. Our observations and findings would not influence the criminal proceedings. Accordingly, we uphold the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in the directions issued by the High Court. The appeals are disposed of. Now, thereafter, the state government, Millot, through its agencies, filed an application before the Honorable Supreme Court. Kindly turn to page 66. The application they filed an application. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9 and 10 and class 11, 12, not found to be tainted subject to the following condition. Kindly see, this is the application made by the state after the Supreme Court judgment was delivered. An advertisement for fresh recruitment to the aforesaid shall be published before 31st May. The examination of the entire recruitment process shall be completed by 31st December. The state government, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May. Enclosing there is a copy of the advertisement for the fresh recruitment as well as the schedule thereof so far as to ensure completion of the recruitment process. The next part is very important. We clarify that this order shall not be read as a conferring any special right or advantage on the aforesaid teachers insofar as the fresh recruitment is concerned. We are not inclined to accept the prayer in the present application insofar as non-teaching posts in Group C and D are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what has prompted us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study should not suffer. Therefore, Lord, on the application by the state itself, Lord, the Honorable Supreme Court was very categorical about Group C and Group D, no concession to them. Now, after this, Lord, this scheme comes. Now, but the basic duty of all the agencies under Article 144 of the Constitution, Lord Shikani turns to Article 144.
কনস্টিটিউশনটা ছিল না এখানে। এটা ফেরত দিয়ে দিন। Yes.
Civil and judicial authorities to act in aid of the Supreme Court. All authorities, civil and judicial in the territory of India shall act in aid of the Supreme Court. Therefore, the obligation was that the authorities must ensure that the Supreme Court judgment is respected and followed. Here, to subvert the decision of the Supreme Court, the state government uses its power under Article 162. Now, kindly turn to Article 162. Article 162 is the extent of the executive power of state, subject to the provisions of this constitution, as placed in Article 144. The executive power of a state shall extend to the matters with respect to which the legislature of state has power to make laws. But what is the power of state to make laws? To unsettle a Supreme Court judgment or even a High Court judgment? Provided that in any matter with respect to which the legislature of the state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon union or authorities thereof. The 162 also does not empower them to make a scheme to frustrate the judgment of the Supreme Court, where Article 144 makes all the authorities responsible and bound to act in aid of Supreme Court judgment. But another article which might be necessary for consideration, kindly also turn to Article 282. But this point may be taken, but though after 162 is categorically mentioned, Milord, this has no application. Miscellaneous financial provisions.
Which article did you mention?
282.
282. Yes.
Expenditure defrayable by the union or state out of its revenues. The union or state may make any grants for any public purpose, notwithstanding that the purpose is not one with respect to which parliament or legislature of the state, as the case may be, make laws. Therefore, 282 is an extraordinary power given for immediate expenditure to be made for a public purpose. Now, they did not take recourse to Article 282, they took recourse to Article 162, but the 160 doesn't empower them to prepare a scheme which deliberately and directly wants to wipe out the effect of the Supreme Court judgment. But on this premise, I would like to, Lordship intervention and stay of this.
41 article.
Article 41 with directive principle of state policy, that's also does no help to them. Article 41, which mentioned, says right to work, to education and public assistance in certain cases. State shall, within the limits of its economic capacity and development, make effective provisions for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. None of the provisions that empowers, I would repeat, my lord, to set at naught a Supreme Court judgment which has declared that the appointments goes because of corruption. Now, this is the first thing.
Would you like to continue? It's already 1:17. I do not have any objection.
Or could I come back tomorrow, my lord? Subject to your lordship's.
But then have you given effect to this?
Yes, it has been given effect to, my lord. I believe, my lord, one installment has already been released.
One installment means it's applicable from 1st of April. So April's money has been disbursed.
No. The notification is issued below.
But I'll come back with better instruction. I'll come
Because
back with instruction.
applications are to be called
Yes,
for,
that-
it
that
has
has
to
been
be
received.
scrutinized, screened. There is a screening process. It will take time. How can it be done so soon?
But I'll take Miller better instruction and come back, Miller. I don't think that I should make any comment on that.
But then please do not distribute the money.
মানে এখন distribute হয়নি তো।
In that case, Miller, I'll come back at 2 o'clock. Otherwise,
এই distribute হয়নি এখন। দেখেন application নিয়েছো তোমরা।